Cremate wealth management, we come with no pretense. Financial advising, making money make sense.
Hi, welcome. Just wanted to take some time today to have a conversation with Drew Alliston. Drew is an estate planning attorney with Anderson Estate Planning, which is a local firm here in McKinney, and have a conversation about estate planning. What is it? What does an estate planning attorney do? What should people know about the field? How can we maximize the field and minimize, issues when it comes to passing on what we own to those who we love, or minimize taxes? So, Drew, thanks for joining us today.
Yeah, thank you for having me, Andrew. It's good to. I love talking about this stuff. Obviously, it's fun to share knowledge and kind of get into the weeds with people and kind of pull back the curtain, so to speak, on estate planning. So I'm excited.
Awesome. Great. Well, I'll just kick it right off and go straight into some questions today. The first one I wanted to ask is let's go real basic. If someone were to talk to you as you're riding the elevator together and say, oh, you're an estate planning attorney, what does that mean? What do you do as an estate planning attorney? What would you say in that situation?
Yeah, that's a great question. That's our 30-second elevator speech. Exactly this. It's pretty much what I tell people is, we're attorneys who help other people accomplish the goals that they want to accomplish in just a couple of situations. One is when they pass away, which is what most people think about. And then the other thing is what happens if something happens to you temporarily or permanently where you're not able to take care of yourself or make decisions for yourself. So who are those people that you want? And so that's pretty much it, trying to help people accomplish the goals and make sure that the things that they value and the people they value are taken care of how they would want to if they were still here.
Awesome. It's a good goal to have in life.
Yeah.
So one of the things that is frequently thought of when people think of estate planning to me are a will, right? Mm-hmm. Your last living testament, right?
Right.
What would you say wills, just general wills, are good for? Mm-hmm. And what would you say they are not so good for? Because a lot of times people will say, oh, I have a will, I'm fine, but that might not encompass as much as they think it does.
Yeah, great question. So a will is typically what most people think it is. And when we're talking about wills in this context, it's what we refer to as a basic will. So it's about 4 pages long. It says everything to my spouse if you're married, then down to my kids if you have them. You name an executor and maybe a backup to the backup. And then if you have young kids, then we also have some guardian provisions in there. And that's basically it. You sign it, get it notarized, witnessed, all that kind of thing. And what that does is basically tell a judge for anything that would go across his desk, where did these things go? Who's in charge of that process? And so what a will is really good at doing is telling the state of Texas, this is where I want my things to go if I pass away, when I pass away, not if, when I pass away. And these are the people that I want to be in charge of that process, which is really good. So that's what it's good for. But what people, there's a couple pitfalls with wills, one of which is just probate. So I think everyone needs a will, but not necessarily everyone will end up using it. And what I mean by that is that probate 9 times out of 10 is triggered by a piece of property, right? So we have our deed that has the names of the couple on there. And when one of the couple dies, that name doesn't disappear off that deed, right? So the only way to transfer property after somebody's passed away is through the probate process, which makes sense from a fraud standpoint. Who said that this is going here? How do we know you're not just cleaning out the estate, all those kinds of things? So the court manages that process. So it's confusing though for people, and especially widows. They're like, this is my house. It's paid off and I want to sell it. You can, but we have to go through probate first. But my husband left everything to me. Yes, but we have to go through probate first. We have to give you the authority to sign on your husband's behalf, right? And so that typically is when probate comes into play, but also with guardianship and all these other kind of things that people don't think about. What a basic will is not good at is deferring distribution beyond the age of 18. So for families that have, kids, they're thinking, how was I at 18 if somebody had dropped $1 million life insurance money on me? Not very good, So, but a basic will, you don't have any options other than that. And so that probably is where I lose most people on the basic will conversation if their life fits that kind of dynamic. We've got teenagers in the house, or maybe our kids are 20, 22, 25, and they don't have they're not all accountants and financial advisors, right? And so they're not ready to handle that kind of a thing if the worst were to happen. So anyway, to summarize, basically, a basic will is really good at telling someone where you want your things to go and who's going to administer that process. But 9 times out of 10, you're going through probate, which isn't the end of the world, but it is a process. And a basic will is not equipped to give you any other options other than full distribution once everyone's 18 years old. So.
Awesome. So let's dive into probate a little bit, because I think that's another question that we get asked quite a bit. First question is, does a will bypass probate?
Yeah, great question. No, it does not. So sometimes there's a little bit of an anomaly where somebody has a will and then it never gets probated because they don't need to get control of any of their assets. For example, when your clients have, retirement accounts, IRAs, 401ks, annuities, life insurance, bank accounts, investment accounts, brokerage, whatever, all of those things have the ability to designate with a beneficiary, right? So if something happens to me, this is who should own the account. And most of the time it works out. And typically people are not going to go at the same time, typically. But so what that means is if, husband passes away and wife is a beneficiary, she automatically gets control of all those assets where she is listed as a beneficiary. So in other words, if they don't own a home and all they have are a bunch of accounts, she has a will, but she doesn't need to use it because the beneficiary rules, right? Which is another important thing for people to understand, is that if you have a will that says everything to my spouse, but you forgot to update your beneficiaries after you got remarried and it all says to your ex, the ex gets everything. The will does not trump it. The will only controls what passes through probate. And the only things that pass through probate are those that have somebody's name on it who is no longer here. So in other words, that bank account without a beneficiary designation, or the bank account and both of you went at the same time, and now the bank has no one to pay out to. So those are the kind of things that will suck you in apart from real estate. And then probate. So just to rephrase what I said, a will is designed to go through probate. So when people tell me, well, my will says everything to me, so it's just everything to me. No, a judge has to handle that. And an attorney, this is interesting, you can't pro se in Texas for probate. You have to hire an attorney, which is kind of interesting. But
Pro se meaning you can't represent yourself.
Yes, exactly. And a lot of people want to. They come and hear how much it costs to go through probate, and they're like, I'll do it myself.
Yeah. So, speaking of that, how are probate costs, factored and
great question.
Yeah.
So probate, we flat fee just like everything that we do because we don't litigate. So we can look at something coming in, see the work involved, and estimate the time that we're going to put into it, and filing fees, all that kind of stuff. So there's no hidden costs for us. Other firms, what they do is they'll charge you a smaller fee on the front side of probate up to the hearing, and then they hourly bill you for every time you email them or call them with a question about a piece of property or something like that, and it balloons at the end of it. So we flat fee, and it's $5,000 currently to go through probate one time, which blows people away because they're like, here I spent, a few $100s on a will, and now I'm spending $5,000 to get everything transferred. And it's just a little bit of a sticker shock sometimes for people. But what they don't realize is there's all of these processes we have to go through to jump through the legal hoops.
Sure.
Which is why the cost is there. But,
so one of the areas that gets probated quite a bit is real estate. Right?
Yes.
Retirement accounts, like you said, anything that has a direct beneficiary, it's a contractual obligation we go outside of probate. But real estate, so let's say a husband and wife live in the same home and are jointly titled
Right.
on that house. That person, that widow in that example that you gave, they still have to go to probate on the property to then have it titled just in her name, correct?
Yes. So that's a really good way of talking about this, a good setup, because it illustrates an important point. The will govern a consolidation of title to the surviving spouse. In other words, Jim and Betty, right? So when Jim passes away, Jim's will says everything to wife Betty. So wife Betty wants to sell her house because it's too big. I don't want to live here by myself anymore. She goes to the title company. They get a buyer interested, and they're like, oh wait, where's Jim? Well, he passed away a couple years ago. Well, I'm sorry, you can't sell this. You got to go through probate now. And then they lose the buyers. They got to go through this whole rigmarole. And Betty, all the while, is very frustrated because she said, well, his will says everything to me. And I've already got all his bank accounts, so what's the problem? And so it's kind of this bifurcated process. Anything with a beneficiary passes outside of probate and outside of the will. But the deed doesn't have a beneficiary on it. It's just the names. And so to get it fixed, to have just Betty's name on it, we have to go to probate court, get Betty appointed as executor, give her what's called letters testamentary, which is just what lawyers call it, and judges, but it's just the legal name. And those letters give Betty the authority to sign anything in Jim's name, and according to the will, right? But it's just strange for people because the will, they would think, would handle everything, and it only handles the probate assets, which typically is going to be your house or
Yep.
other property.
So let's dig into that a little bit more and see if we can give people some options here.
Mm-hmm.
How can you set up your personal residence
Mm-hmm.
in a way that would be outside of probate? Do you have a couple suggestions for just general, ways that people go about this?
Yeah, there's two ways to do it, and one way works sometimes. Well, let me rephrase, it'll always work. One way works really well sometimes, and the other way works really well all the time. So when we're advising people, it depends on the scenario. So one of them is what people typically call a ladybird deed, which is an enhanced life estate deed. So it's very important, just a couple legal jargon. If a client is ever looking at signing a life estate deed that does not have that enhanced word on it, you don't want it, because what it means is I'm going to keep the current title, but when I pass away, I'm giving the remainder to somebody else, and it's an automatic transfer. But a traditional life estate deed, there's no givesy backsies, right? You're locked in. You can't undo it, and you can't sell it. It's kind of a thing, which is a problem for a lot of people, which is why we have an enhanced life estate deed, which is what people refer to as a ladybird deed. What it does is it says, this is mine now, but when I pass away, I want it to go here. Same setup, but the person forming it has the ability to revoke it, to change the remainders, right? I was going to give it to my kids. Now I'm giving it to my new husband or whatever, right? You can do whatever you want there, including sell the property. So it's very flexible, which is why we like to see it used. So I just wanted to explain that briefly, the difference there. But the way these work really well is when you have a widow and she has her house and just some bank accounts, investments, whatever, but they're all beneficiaries. And it's a very simple family dynamic. And what I mean by that is I've got one child, no special needs, no debt to speak of. Here it is. Everything's going to my one daughter. And in that situation, I'm like, it's good that you have a will as a backup, but really all you need to have at this point are the beneficiaries lined up and then a ladybird deed to transfer your property when you pass away. Now, again, the reason I said it works sometimes and not all the times is if you have a married couple, it's very difficult to do this because you both own half of the property. And typically, they want the survivor to own the whole property. And so you can't file concurrent ladybird deeds because you don't know who's going to pass away first. And so it doesn't really work in that scenario. And then the other thing that I feel like is not a great setup for people is when you have say you have a blended family where people are going to fight and bicker about things. Maybe you have a child with special needs. There's just different things occurring besides just the transfer of this house. And typically, if it's any more complicated than my first example, we recommend a trust, because the trust is not just dealing with real estate, it's dealing with everything. And so you can actually designate the trust as a beneficiary of the retirement accounts. And we have special language, which is not as amazing as it used to be because of the recent legislative changes on your end. In other words, you can't stretch, the RMDs for life, that kind of thing. But it makes it to where anything can pass inside of that trust without negative consequences, and then you can handle a disbursement privately, which is a big deal for people. But it just depends. So most people come to me and say, hey, look, Drew, we're not the Kennedys, we're not the Rockefellers, we're very simple, right? That's what everyone says, we're very simple. Maybe not. Maybe your assets are simple, but maybe your family dynamic is a little more complicated. Or maybe your family's simple, but your assets are kind of complicated. And so that's why I try not to make decisions for people or hard recommendations, but I just want them to understand the pros and cons, because almost everybody wants the ladybird deed because it's cheaper at the end of the day, right? And what I try to tell them is you might save a little bit of money on the front end, but it's going to cost you in the long run based on your circumstances. So
Right.
Hopefully that makes sense.
Yeah. So I guess you mentioned kids, right? Being involved. So let's say someone wants to talk about how do I protect my children through estate planning?
Yes.
So normally we're talking about a minor, right? We're not talking about adult children.
Mm-hmm.
In those situations, they have a guardian that's appointed in the will, right?
Right.
I want them to take care of me. I guess a couple questions here is, one, do you typically see a guardian for the children and a separate guardian to oversee the finances done in your experience? And then the second part of that question is, how do you normally advise clients to structure retirement account beneficiaries, since minors can't be in possession of an account that they inherit, from
Mm-hmm.
just a transition standpoint?
Mm-hmm. To answer the first part of your question, what I always ask people, excuse me, is who are the people that you want making care decisions, right? So who's your touchy-feely person that isn't going to pull the plug on you prematurely, that loves you, wants to spend time with you? Who's that person? And then who's the person that's the numbers guy or girl, right? Who's that person that is most comfortable dealing with the books all the time, that loves paying bills, which there's really no one that loves paying bills. But my point is, there's people that typically either gravitate towards one or the other. Oftentimes they're not the same person. So to answer your question, people will say, well, I really want, our dear friends so-and-so to be guardians of the kids, but I really want my brother to manage the money, because as much as I love these dear friends, they're going to love those kids. They're going to do what's best for them. If I gave them these retirement accounts, they'd be broke in a year, And so I need somebody managing that separate and apart to make sure that it lasts as long as we need it to. Now, that being said, sometimes they're the same people. It's just kind of rare. Usually those are very different. And so we just try to categorize it: numbers, care, love and feeling versus kind of analytics, right?
Mm-hmm.
It sounds harsh, but that's kind of how we recommend it. And the benefit too, when people work with us, is that you can change it all the time. And people do, right? People move, people have falling outs. Sometimes people just die. And so you can always update these things. You just got to kind of stay on top of it. To answer the second part of your question, people are constantly telling me, well, I just put my minor kids as the beneficiaries on my retirement accounts or my life insurance policies. Like, you can't do that. It won't pay out. So the good part is, from a policy standpoint, is unless you're 18 years old, you can't get anything. So those minors, the court takes it, right, in trust, and it's not in a trust, it's just in trust for them. And then the guardian approaches the court every time they need money for the kids' school clothes, who knew they would grow over the summertime, vacation for the family, new minivan because we have 3 extra kids, that kind of a thing. But once they hit 18, to my earlier point, ta-da, here's your $1 million, Mr. 18-year-old, have a very successful life, and they spend it in about 20 days. So the way that we recommend is there's really two ways you can handle it. One is a will route. It's a fancier will, not a fancy in the sense of being uppity or whatever. That's a bad word to say. It's more robust. It has more options. And then, or a trust. Either one of those you can designate differently. The problem is really, I just dealt with this the other day where somebody said, I'm going to name my kid's trust as the beneficiary under this retirement plan. I said, oh, great, you have a trust. Let me look at that. Well, it wasn't a trust. It was a will that had a contingent trust built inside of it, but the trust doesn't exist yet. And so it's that chicken or the egg problem. And so typically the full-on revocable trust is the best way to handle it when you've got young kids. It doesn't mean you can't do the other, but it can have complications. But with the living trust, it's different because a will is an on-death document, so nothing happens until somebody passes away. And even then, it's a time release. It takes time to get somebody appointed and to create that trust out of that language and all that kind of thing. With a revocable living trust, it's living. So the minute you sign it, it's there. So putting a trust as a beneficiary instead of your kids, it's active right then and there. So if you passed away the very next moment, that trust is already there ready to receive, and then your trustee is ready to equip and take care of the kids. So that's typically how we recommend it. That doesn't mean everyone has to have a trust, but you really got to think through those things. And one thing, which I'm sure you deal with a lot, we hear people say, well, I understand what you're saying. I don't want to do the trust route, but what I will do is kind of an in-between while the kids are young is I'll just have my brother. I'll give everything to him, and then he will take care of my kids. And so what I tell them is I say, your brother is probably a wonderful person and means very well. Here's how those wonderful people use the money. They lose their job, right? Their car breaks down on the tollway. They have a nasty divorce. Just things happen. And as they happen, that good person thinks, I'll pay back those kids money, as soon as I can, but they keep using this money that's technically theirs, and there's no recourse. And then over time, they just siphon it away, and there's not hardly anything left when the time comes.
Yeah, I've definitely seen that. And then the kids end up growing up and suing that.
Yes, which is not what anyone wanted.
Right. So in your opinion, do you think that everyone needs a trust or could use a trust, or do you think they're overused, or what are your thoughts on that?
I think that a lot of professionals tend to have kind of a pet document tool that they love, right? And so there's some attorneys out there that say, all you need is a will, period, done, it's all over. But what they're really doing is they're banking on the fact that they're going to get a huge boost in probate 20 years later, right? They're kind of building a retirement for themselves as an attorney. And then you have other attorneys that say, all you need is a trust. And they're just taking that fee up front, and that's just kind of how they want to do it. And so what we try to do is just say, look, here's how it all works. Most people that come to us say, I just want a will because that's what they've heard about. That's what their parents had and their parents had. That's what they've experienced. And then we hear about like the Kennedys and the Rockefellers having these like gigantic trusts, and we just think it's an asset-based tool. So what I try to do, most people sort of understand what a will does and doesn't do. But on the trust side, trying to help them understand it's a planner's planning tool, right? And so for people that really want to have maximum control when they're not here anymore, or even when they are just disabled or something, the trust gives them the maximum flexibility, and it's the most private, and it has the most guaranteed outcomes. You're not in court. With a will, you start out in court. So if somebody's wanting to fight about something, they throw their hat in the ring. It's real easy, right? And so to answer your question, I think most people come into our offices thinking all they want is a will, and they typically leave with a trust, not because we're pushing it, but because most people planning in advance are doing so because they want to control things as best they can. and they want it to be as simple as possible. And so a lot of those people go, oh, that is a lot better. And then it's just a price issue for them. Do I care enough to spend the extra money on it?
Yeah.
But
So I've got a pretty good number of clients that have businesses.
mhm.
And do you typically recommend that business owners take their company and also put it in a trust if they have a trust? And if so, why? As opposed to just having the, articles of incorporation speak to if this person passes away, then this person, retains ownership or anything like that.
Yeah, that's a really good point. So this happens a lot. What people do is they have maybe they have a buy-sell agreement. That's best case scenario. Worst case scenario, they have their articles of incorporation that say who gets it when they pass away. We have the same problem with the house. When somebody passes away, who can execute? Who can sign over the shares? Right? Now, there's an argument to be made if it's a small business. Nobody's going to argue. You just kind of do the deal. But typically, when somebody passes away and you've got multiple parties, and then now you have a spouse of your business partner that you're now dealing with, they want to get paid pronto, and there's sometimes a lot of things that can kind of come into play. And what people don't realize is that who's going to sign, right? We have to take that business through probate. And so if you're about to sell your business, you're wanting to merge with somebody, or you've got a buyer lined up ready to go, or you've got debt that you're trying to offload, all these business type things, they get all frozen essentially through the probate process. In Collin County, it's pretty quick to get on board with a probate, maybe a month, something like that. Other counties around us, it can take 6 months just to get a hearing and to get somebody appointed in order to sign over the shares. And so when I mention that to people, they start to go, huh, okay. And so when they realize that, understanding putting a business in a trust, what you're doing is you're giving whomever your trustee is, you're giving them the ability to sign over those shares. They still have to follow the rules, but you don't have to get anyone appointed by the court, and you can handle it all yourselves. And so you could literally have, it sounds callous, but you could have somebody pass one day, and the very next day, you could have all the shares of the company, assuming payment's been made through life insurance or some other feature. It's all done. It's settled. And then the business doesn't skip a beat. They keep going. Whereas in this other option, if it gets tied up in probate, it could kill a business potentially, especially
So,
needing funding.
yeah. So what items cannot or should not be held in a trust?
Great question. Retirement accounts, so your IRAs, 401ks, life insurance, and annuities they're never inside the trust. We designate the trust as a beneficiary is kind of a catch-all. So we always leave spouse as primary, but especially when there's kids involved, we just add the trust as the next in line. And then when they both pass away, whatever that retirement asset is, it funnels inside the trust. And then specific to IRAs, we have what we call conduit language, which allows it to go through without causing that tax trigger. Because that's what everyone's worried about, right? I don't want my kids that pay upfront full taxes on the whole. I want them to kind of have it as a trickle and with their RMDs, which unfortunately is 10-year max now, but it's still 10 years, and so unless people have, multi-million-dollar IRAs with only a couple kids, it's not typically going to cause a massive tax event. But without that conduit language, it will cause that trigger. And so that's what a lot of people don't realize and don't know to look for. So to follow up with that, everything goes in the trust except for these qualified retirement accounts that would have a tax trigger on it.
And I mean, you and I both talk about trust, and we kind of understand what we're really talking about is revocable living trust
Right.
predominantly here. Just, I think sometimes people get confused. Can you maybe give a little overview for everyone? Just explain revocable versus irrevocable and how they're really quite different, and how you wouldn't want to put a business, for example, necessarily in an irrevocable trust, right?
Sure. So 95%, I'm pulling that number out, but that's pretty close. I would say 95% of the trusts we put in place are revocable. And the reason for that is there's all of these benefits. And then there's 5% that we do that are irrevocable. And the reason it's only 5% is because there's only a few benefits to having it. And it's a very narrow grouping of people that fits it. So just to get that out of the way, typically the only time we're doing irrevocable trusts are for somebody that's needing government-based benefits. In other words, there's a benefit out there that my child or my spouse or someone needs access to, but we have a little bit too much assets. Now, if I put them in an irrevocable trust, I might qualify, or my spouse or my child might qualify, so that we don't have to dip down into poverty in order to qualify for this benefit. And so it's a very good tool. But there's some negative consequences. Typically, you're paying trust tax rates, which is going to be upwards of 40% over a certain amount annually. And then you can't change it. Once you've created it, it's irrevocable. You've locked it in place. And so people's lives change, circumstances change. A lot of times people want to change these documents, and with irrevocability, you can't almost all of the time. There's a few allowances there. So when we're talking about trust, it's always almost going to be revocable. And the reason we do it that way is that it's a flow through for taxes. So when a person has this type of a trust, you don't pay separate taxes, you don't file separate taxes, you don't have to get new bank accounts or checks or anything like that. It runs off of the person's social security number, which is huge. That's a great thing. So for flexibility, it does avoid probate if properly funded. And then you can change it anytime you want, which is the best part. You're not giving away control to somebody else to manage those assets for you. You're still in charge, which is what most people want.
Right. So we talked a lot about wills, about trusts. There's a few other pieces that I know I always talk to clients about in having, powers of attorney, both durable and financial, and medical release forms and advanced directives. Can you kind of talk a little bit about all those? Just explain what they are so everyone understands, and talk about maybe how they're used and maybe some ways that they might not be used as much as they should, right?
Yes, that's a great question. So there's really 4 that we cover. The first is your durable power of attorney. Sometimes you'll see people, they'll have what's called a statutory durable power of attorney. So that's actually in our state statutes. So legislators, people tend to be lawyers. And so they've actually voted that in, and it's part of, you can look it up online. It's free and able to be downloaded. It's a good form. It's not a great form. And the reason I say that is because it gives the person that you have nominated as your attorney, in fact, your agent, right? Whomever can do things for you. It gives them the ability to accomplish things in these categories. So it's bullet points, right? Real estate transactions, trust transactions, banking transactions, all these different categories. So when people bring us as a law firm this statutory durable power of attorney, they say, Mom has a piece of land. She's incapacitated currently. I need to use her power of attorney to execute a deed so we can sell the land. Great. Real estate transactions, no problem. The problem is when you go to a title company, a bank, or anyone that has a legal department, they're going to really look at your particulars to see how well it fits inside that bullet point. And if it's at all beyond what they want to extend themselves on, then you have to go find somebody else because they're not going to help you. So what we do is we take those categories and we expound upon them. So instead of about 6 pages under the statutory form, our durable power of attorney is about 25 pages. And it just covers anything and everything that can come up. And what we tell our clients is, look, if they don't cover it, come back to us, and it's our form. We'll push it through for you. We'll argue with whomever we need to say, no, this really does apply in a polite and good way. But it's really important, because what's happening with this durable is anything that you can do for yourself legally or financially, you're giving someone else the authority to do for you on your behalf. So selling a house, opening a bank account, closing a bank account, talking to the Social Security Administration, talking to the Utilities Department, opening a website, closing a website, digital assets is a big deal now. And so anything like that, it gives you the authority to handle it. And what I see these most often not used for, which they should, and I'm pretty sure you'll agree with me on this, is many many families at some point in their life will put their kids on their bank accounts. It's a lot of times as owners. And I say, don't do it. Please don't do it, because what they don't realize is that kid's liability attaches to that account. So if the kid gets sued for anything, they can reach in and grab mom's money because it's also kids' money, right? And they don't realize that. So what I always tell people, look, you've got mom's durable power of attorney. It gives you the authority to do things. So just give the bank the power of attorney. They keep it on file, and you can cut checks when you need to. You can make withdrawals when you need to. And in that way, you're doing it as an agent on behalf of someone as opposed to as an owner, if that makes sense.
Mm-hmm.
Okay, awesome. The second one is medical power of attorney. Most people are familiar with this. You go to the hospital, they provide you one if you don't have one. The biggest problem that we see is that people wait because they know it's going to be provided to them. They just don't have one, right? Well, they'll provide it. Not if you're in a coma, And so what we say is you really do need a universal document that doesn't have Presby or Baylor or someone's stamp on there, because after a certain period of years, if they have some updates or whatever, they're going to say, well, we can't honor that form anymore. It's been longer than 2 years or whatever. And if you don't have a form, you're kind of out of luck at that point. And so the advantage of having a universal medical power of attorney is that you have your people, and it doesn't matter where you go and what state, what jurisdiction, what hospital, they're going to honor it. And then we build the HIPAA release inside of it, which is also super helpful. So you can get second and third opinions. The third is the most misunderstood, and it's kind of backwards from a power of attorney, because you're not giving anyone the authority to make a decision. You're giving someone the authority to release a document. So what this is the pull the plug document that everybody talks about. And what you're really doing for yourself is saying, if I was ever in a vegetative state with no hope of recovery, how do I want to be treated? Do I want to stay on life support, or do I want to go naturally without pain, of course? And so when you make that decision for yourself, it does two things. It keeps your family from fighting about it. What did dad want? What did mom want? All those kinds of things. And then you're also not having the burden of, did I make the right decision? And so it's like, just do what dad said. He didn't want to be prolonged artificially beyond hope, right? And so it's a really, really good document. Hopefully they never get used, but when they do, it's such a blessing to the family to kind of have that already lined up. And then the final one, most people I don't see have this one, and it's today especially much more important than maybe it used to be. It's called a declaration of guardian, and we think about guardianship for our kids, but this is for us as adults. And what it says is, should I ever need a guardian appointed over me, who is that person? And so typically we see this enforced a lot with Alzheimer's patients, any kind of memory disease where you have a relatively healthy body, but they're resisting care because they don't really understand what's happening. So a facility will never take someone against their will unless a guardian's been appointed over them. So you either have this piece of paper that says, these are my people, or you go through a living probate that a judge appoints an attorney to protect your interests, and then the family essentially dukes it out for whomever is best suited to be the helper and to be the guardian. And so what people don't realize is they might end up with somebody that they really don't want making those decisions, and it's expensive. It's like a 2-year process sometimes to get through that court battle versus a 2-page one and done document. Please, it's already been handled. Just honor the piece of paper. So
Right.
Those are the 4 powers of attorney that we talk about. We advise them for 18-year-olds as well as 80-year-olds, because we kind of advise people, whether or not they take us up on it, do kind of a going away college package for their kids. And what parents don't realize is once your kids hit 18, you're not automatic anymore. And so having these powers of attorney, even for a young kid, 18-year-old, it gives the parents the ability to be parents still, if the kid wants it, right? That's the one caveat. But oftentimes they do, So.
Yeah. When I used to work back in the hospital setting, that was always a big problem is, 19-year-old in a car crash comes in, parents come in, sorry, we can't tell you, what's going on.
Yeah.
And they're not on life support. This isn't an end of life situation. Here's the bill. You can pay for that, but we can't, tell you more.
Yeah, it's hard. It's an unintended consequence, but the reality of kind of where it is.
Yeah. So, kind of wrapping up, I guess one of the things I definitely wanted to touch on is overall costs.
Mhm.
What do these things typically run when someone wants to talk to an attorney? And then the other piece of it is how are your services, how are what you do a little bit different to LegalZoom, US Legal Forms, one of these online platforms where people can just go do it yourself? Like, what would be the right situation for someone to say, you know what, I think I need to talk to someone versus I'm okay downloading this form and doing it myself?
Yeah, yeah, that's good. Those are good questions. The first question on pricing, we are a little bit different in a couple ways than a lot of other estate planners out there. One way is that we do charge an initial consultation fee, which is a little bit unique. It's not a lot. It's $350, and it's an hour and a half of our time deep diving into this person's life to make the best recommendations possible and educate that person. So anyone who's even hesitant on talking about it, I just say, look, when you leave this meeting, you don't have to work with us, and you can go to any attorney in the world and tell them at that point what you want and why you want it. And so I think most people, they go, oh, okay, this is helpful, because it's not a bait and switch tactic to get people in the door and well, now you know our prices, now you have to pay them, that kind of thing. It's very much just to protect our time. And also what we found is that when people pay just a little bit of money, they are more serious, I guess, just about wanting to do something, whether it's with us or with anybody. So
Mhm.
we do charge an upfront fee. And then at the end of that meeting, we're quoting them to the penny what it would cost to do any of the plans that we've recommended. Now, typically for a married couple, it's going to range from like $3,000 to $6,000, depending on what they're wanting to do and how complicated it is, because our model is all inclusive. So you're paying that one fee, and then we're your resource onward, right? So when your kids want to meet us at a certain age, you bring them in, we meet with them, we talk with them. When you need us to update beneficiaries or an executor swap or something like that, we do that. So once we have the client and once the documents on our computer, we're doing the work. There's no after billing that happens. So sometimes people feel that our prices can be a little bit higher than others, which I disagree with. I mean, there's always somebody cheaper, but there's also people that charge a lot more. But we just try to be that middle value to the client, and I think the main value is the thoroughness on the front side, and then the relationship they have after the fact with us. But it just depends on kind of, which people don't like to hear, but it does a little bit. But that's a pretty healthy range for what people can expect, and it's all encompassing, which is good, because it means whether you're on this end of the spectrum or on this end of the spectrum, it covers everything that you would need. It's just different processes.
Sure.
So,
And
and then, yeah, go ahead.
yeah, just how does working with an attorney differ than online option, right? When you just,
Yes.
because I
So
think they're so far apart in what you do, and maybe you can verbalize it
yes,
from your perspective.
yes. So in our world, that was kind of the big concern for a long time. Is LegalZoom going to put us out of business? And I can confidently say, without a doubt, it absolutely won't happen, because at the end of the day, this is still people. And although LegalZoom and Rocket Lawyer and all these other websites do a good job, they provide a good document. We've looked at them. They're not bad. The problem with that process is you're relying on the client to tell the program what they need, and they're going through a range of Q&As that may or may not touch on what's actually going on. So in our intake process, when I'm meeting with the client for that initial consultation, we go through our estate planning worksheet. And then I always ask them right before I start with the education piece, is there anything that we haven't talked about yet that you feel would be helpful for me to know? And 9 times out of 10, people say stuff. Oh, I forgot to tell you about this. Oh, I forgot to ask you about this. And it's these nuances that people think are not a big deal that end up tanking whatever they were trying to accomplish, but they never know it. And so it's very similar, I feel, to the financial investment industry, right? People think I can do this better on my own. I can make these decisions. It's not that complicated. Maybe, maybe not. But are you going to dedicate the time to it that you need? Are you going to ask the questions that are important? And do you even know to ask those questions? You don't know what you don't know.
Hmm.
And so what I always tell people, if you want to do those other things, go for it. Best of luck to you. The problem with it is, and it's not a scare tactic, it's you get one shot at doing this right. And if you've done it wrong, you're now subject to however you've locked yourself in. And so to me, I feel that it is so worth it to spend a little bit of extra money to have the peace of mind knowing that what you're actually seeking to accomplish will get accomplished, and that the people that you care about have somebody to talk to. Because even with Rocket Lawyer, they still have to find a probate attorney at the end of the day if it's a will. And if they need their trust updated, or say the trust is in existence and mom and dad have both passed away, now the kids are like, well, what do we do? We have this document. Now we need to go find an attorney. And so to me, it's like, let's find one attorney who can draft this thing so that we can also have somebody to get mad at if he does it wrong, right? Which won't happen. But, it's just having that people dynamic that I think is so important. And as good as technology is, I don't think it will ever replace that factor for people.
Yeah.
So,
Awesome.
what is that your opinion on your side as well?
Occasionally people will say, there's online services. Why pick you over going to Vanguard, right? Or something like that. And I always say, well, I'll pick Vanguard to answer that, because
Yeah.
they did a study, and
Yeah.
it said, well, what is an advisor worth? And it showed on average an advisor provides a 3% higher return on your portfolio. And it's not the investments. The investments were worth zero.
Right.
It was all the other stuff that actually
It's not making emotional decisions when you're not supposed to, right?
behavior was about half of it. Absolutely.
Yeah.
Yeah.
Yeah. So that's interesting. Yeah, it's very similar. It's just on the Vanguard side that they're making daily decisions probably, and here it's kind of one decision. And that's, I guess that's the other problem with the online stuff, or anything really, any advice that you get, is that when you address an issue, you feel that it's now adequately addressed. And that's the problem that I see, is that most people, when they do the online planning, they haven't adequately handled what they were wanting to, but they think they have, so they don't worry about it for 40 years. And then somebody passes away, and then they realize, oops, we made a mistake here. So,
Right. Awesome. Well, I appreciate you taking the time today and talking about all this. And I'm sure lots of people will get, lots of good information from it. So thank you.
Absolutely. Yeah, thank you, Andrew. I appreciate it. It was fun.
Absolutely. And we'll have everyone's contact information at the end. If anyone has any further questions, they'll feel free to follow up with Drew or myself directly.